or no? Okay. All right. Court is calling 2025 CR 000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed, is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication-assisted treatment. There was nothing else, no other substances.
All right, so the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case, and when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court?
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced, but I verified with felony drug court that should she be placed on probation, they are able to accept her and can squeeze her in.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time.
All right, guys, buckle up, because today's courtroom lineup is packed with drama, tough decisions, and no-nonsense rulings. We're diving into 3 cases, each showing how the justice system can shift between mercy, strategy, and sheer accountability. From a woman fighting addiction who's hanging on to her last chance, to a defendant's attorney begging for more time, to a no-show who thinks she can dodge the system. You're about to see it all. This isn't just law and order. This is raw courtroom reality at its finest.
I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're going to see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed, but the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right.
We start with Elizabeth Settle. She stands before the judge, her future hanging by a thread. This isn't her first time facing consequences. She's been down this road before. The probation officer lays out her history, explaining her struggles with substance abuse and how the system has tried to work with her. The tension is thick. Everyone knows the judge has a choice: send her to prison or give her one last shot at turning her life around. The air in the courtroom feels heavy with expectation.
And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee-high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. Mm-hmm. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. Mm-hmm. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? Mm-hmm. And I think the distinction between this time and last time, she did not do what she was supposed to do for you, Judge. It's very clear in the PSI. Back in 2020, she was going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS. She's been compliant. She's been enrolling programs. She's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off. She's not fled. She's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves.
Elizabeth's defense doesn't waste time. They argue that prison won't solve the root problem. Instead, they push for treatment through drug court. They say Elizabeth is showing progress and needs help, not just punishment. The defense paints her as someone who could make it, if given proper support. But the judge cuts through with sharp words. Treatment is not a free pass. If she gets probation, she's walking a tightrope. One slip, one violation, and she's done. The balance between mercy and punishment is on the line.
Don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order to enter the drug court program.
All right. Anything you wish to add, State?
Judge, the state stands by its concern about Miss Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for very structured supervision, because I do believe that it is a necessity in Miss Settle's life at this point. I believe drug court would be appropriate, and if needed, inpatient treatment.
All right. So, the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand?
Sure.
And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, John?
All right. So normally, legally and ethically, I'm not allowed to interfere with negotiations.
All right, guys, here's the turning point. The judge takes a deep breath, looks Elizabeth square in the eye, and delivers his verdict. He's giving her deferred adjudication with probation, but with strict conditions. That means no mistakes, no excuses, and mandatory treatment. Elizabeth's face shows relief mixed with fear. Everyone knows what's at stake. Either she proves herself, or she'll face prison down the road. This isn't just leniency. It's her final warning. The courtroom moves on, but the weight of this decision lingers.
But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underline of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Yes, ma'am.
All right.
Judge, on the second degree case, is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's the state is opposed, but there is an application for deferred on that case.
Okay. So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed?
Well, no, on the unlawful, we're off the record, on the unlawful possession of the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you would be subject to the full range of punishment if you were revoked. Do you understand?
Yes.
Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
Now we shift gears to something entirely different. The next case features Angel Sepis Ronda, and instead of personal struggles, this one's about courtroom chess. Angel's defense attorney is fighting tooth and nail, not for freedom today, but for more time. They claim they haven't had enough time to prepare for trial. Discovery is late, some records are missing, and witnesses are hesitant. The defense makes it sound like the system stacked the deck against them. But will the judge buy it? Not likely.
And Ms. Abrams, on Ms. Settles, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. Yes.
The case ending in 240, are we proceeding on count 1 or 2?
Let me see. They're proceeding.
Okay.
They're proceeding on count 2 as a repeater. I'm sorry, wait a minute. They're proceeding on count 1. They're waiving count 2 in the repeater.
Judge,
Yes.
here's that docket back, and we initialed the plea bargain change.
All right, thank you, Hunter. All right, we're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state, Judge.
No, just that we have no objection to the change from the cap 6 to the cap 10 here.
All right. Then in cause number 2025 CR 000240, the court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, There's to be no employment as a home health care provider or with minors.
The defense lays it out clearly. Without the missing records and time to talk to witnesses, the trial won't be fair. They press the urgency, warning the court that rushing this could harm Angel's right to a proper defense. It's a bold move, leaning on the Constitution itself to argue their point. They paint a picture of being handicapped by the state's late evidence. But the judge leans forward, eyebrows raised, skeptical. He's heard these arguments before, and delay tactics are nothing new in his courtroom.
This is the run concurrent with 2024 CR 013090. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
All right.
All right, what date? All right, we're going to come back on September 11th and state this just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
Just one moment. Deputy Laura, are you okay? Thank you. All right, there's to be no contact with Rudy Rodriguez. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be.
Here comes the clash. The prosecution fires back, saying the defense has had more than enough time. They insist they've turned over the necessary discovery and that this case is ready for trial. No more waiting. No more delays. The state argues that justice delayed is justice denied. They frame the defense's request as nothing more than a stalling tactic. And you can feel the judge's patience wearing thinner with every word. The courtroom tension spikes. It's a battle of timing and strategy.
Deemed satisfied. There's a $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please, no contact, did you say no harmful or injurious?
No harmful or injurious contact with PECK, PECK, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, THURSTEN, Juan Uriega, David Getz, GOETZ, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fly in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing and that cause number, counsel?
Nothing from the state judge.
Nothing from defense, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. And that cause number, did you review it with your attorney? Did you?
All right, guys, here comes the hammer. The judge looks straight at the defense, takes in all the arguments, and makes his ruling. Motion denied. The trial will move forward on schedule. No excuses, no extensions. The defense has no choice but to prepare as best they can. Angel's face shows disappointment, maybe even fear. That safety net is gone. The judge makes it clear. This court runs on accountability and deadlines, not endless delays. The trial clock is ticking, and Angel has to face it head on.
Do you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're moving to cause number 2024 CR 01309. All right, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. 200 hours of community service restitution. The court will show that 100 hours is satisfied upon the completion of parenting classes. GPS, and I'm sorry, probation will do partial GPS for employment and treatment in each cause number. Waive GPS fees. This is run concurrent with 2025 CR 000240 and referral to felony drug court. And again, if felony drug court for some reason does not accept her, she's to come back to this court. Probation, is there anything else with regards to sentencing?
It's on the other call number as well. Bill visit.
With that, we move to the last case of the day. And this one is about as bad as it gets for the defendant. Pearl Gonzalez doesn't even show up. The courtroom calls her name, but her seat is empty. Already, that's a problem. The probation officer explains she hasn't been reporting, failed to provide a drug test, and basically ghosted the entire system. The tension here is different. It's not about mercy or strategy. It's about someone completely ignoring the rules.
Oh, thank you so much. Field visits one time per month until further notice.
And can you clarify which count on that call number?
The one I just read, the unlawful possession.
Yes, sir.
They are proceeding on count 1 and they're waiving count 2. Is there anything else with regards to sentencing in that cause number?
No question.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You say you have a new child. Your counsel has told me you have a newborn, that you have finally, the haze has been cleared and you're finally going to do what needs to be done. In each of these cases, in one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself 2 questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you, Judge.
Thank you. It's always great seeing both of you guys.
Me too, Judge.
All right. Thank you. So, Hunter, how's it been going?
And good.
No, I don't have it. All right.
The probation officer lays out the facts. Pearl was given conditions to follow while out on pretrial release. Instead, she skipped drug tests, failed to meet her supervision officer, and stopped showing up altogether. The officer's tone is calm but firm. This is not a mistake. This is blatant non-compliance. You can almost see the frustration in the courtroom. Pearl had her chance to prove she could be trusted, and she threw it away. The judge doesn't need long to process this.
So, first things first. It's on page 2. First things first. Why were you late for court? Court starts at 9 a.m.
You were telling me about. I was in court, pero no dime myself, no dime. But I didn't give my name, but I was here.
No, I call the docket at 9. And when people answer the docket, then I check them off as having appeared. But you're scheduled for jury trial today.
That's correct, Judge. We filed a motion for continuance on this.
All right, as soon as I get the file, we'll see about your motion for continuance. Okay. Okay. All right, the court is calling 2025 CR 002807, State versus Angel Cepedes Randa. Can I have parties announced?
Ashley Jones for the state.
John Reitmeyer, yes.
All right, and are you Angel Randa?
Yes.
All right, we have an interpreter. If the interpreter could raise your right hand, do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right. Defense, you filed a motion for continuance.
We did, Your Honor. In getting ready for trial, we've subpoenaed several records that we haven't been able to receive yet. One of them, we were told the staff is not back from summer vacation. The other one, they paused our request and sent it to the attorneys.
All right, guys, here's the judge's breaking point. He looks at the empty chair, shakes his head, and lays it out plain and simple. This is not how you treat the court. Pearl thought she could disappear, but the law doesn't forget. The judge makes it clear. There's only one path left, and it's not freedom. The officer's report is enough evidence. Pearl Gonzalez didn't just mess up. She flat out ignored every responsibility placed on her shoulders. And in court, that comes with consequences.
General's Office for review for open records. We've had issues getting witnesses that could help the defense due to several fears that they may have about coming to court. With that said, we did receive a late disclosure from the state about 404B evidence that I haven't had time to go through. There's also been another late upload to e-discovery that I was able to look at. I have talked with the state. I don't fault them for the late disclosure, but...
Well, now, here's the question, because this has been set for jury trial since May. This has been on the court's docket since April. So what was uploaded late?
It was about the complaining witness in a meeting that they had. There was a name that was mentioned in this interview with her that we have not seen before, who may have information.
And when did this interview with the complaining witness take place?
Your Honor, we met with the complaining witness last Tuesday. It was quite a very long interview with an interpreter with Mr. Caesar here. And that's when we received the information and we uploaded it over the weekend. And
this is what I don't understand, and maybe somebody can help me understand. I don't understand how a case is indicted and then the state is speaking to the complainant, you know, a day before trial or a week before trial, and all of a sudden there's new discovery. Like, why is everybody waiting till the last minute to speak to a complainant? All ducks should be aligned and in a row. Maybe I did things differently when I was a prosecutor, but once I had and took a case to indictment to a grand jury, I received all the information, done all the investigative work. And if I met with...
The ruling is swift. A warrant for Pearl Gonzalez's arrest. No hesitation, no second chances. The judge says it with authority, and everyone in the room knows this is the end of the line for Pearl's pretrial freedom. Once that warrant is out, the system will catch up to her, and she'll be back in custody. This isn't punishment for failure, it's punishment for disrespect. Pearl made her choice, and now she'll pay the price. The courtroom moves on, but her story is a clear warning.
A witness, I would tell them, this is the day we're going to trial. What you need to do is listen to the questions, answer the questions, and tell the truth. That was the extent of our meeting. I don't understand waiting and then interviewing a witness, then obtaining all this new information, then dropping it on the defense. And we're scheduled for trial. I don't understand.
Well, Judge, in addition to my own reasons, I understand the state has a reason for themselves.
Yes, Your Honor, I can speak to that. We do have an officer who is out of town starting tomorrow. As the court may or may not know, there was a translator needed for the investigation that was done. We were able to get a hold of that officer, and he is out of town and starting tomorrow.
All right. So as far as the state not having its witness, the state is not, the court is not going to grant a continuance based upon the state not having their witnesses. That witness, everybody knew this was the jury trial date because everybody was here when we said it. So, and then with the 404B?
Well, it was late notice. I haven't had a chance to go through that, Judge. I just got notice of the filing yesterday.
Well, has the law changed with 404B notice that can be given up until the day of trial? What's in the 404B?
And Your Honor, I can speak to that. It's actually stuff under 3837(1)B, which is just nature of the relationship stuff. It was a couple instances that the complainant described that described the nature of the relationship throughout.
Well, that's not coming in. So what's the next issue? Any 404B that is related to their relationship, that's not coming in.
Then, Judge, it would just
was just dropped upon you.
It would just be my original. We had subpoenaed records for trial, and we don't have them.
When were the records subpoenaed?
Let's circle back and reflect. Elizabeth Settle was given a chance, and not many people get that kind of last rope. The judge's decision wasn't just mercy, it was a gamble. He's betting that treatment and strict probation can keep her out of prison. But if she stumbles, she's not just letting herself down, she's letting the system down too. Her case highlights the fine line judges walk when balancing accountability with rehabilitation. She's a test case for how mercy can play out in the justice.
Offhand, several weeks ago. I don't have an exact date I'm talking about.
All right, so I need to know when the date the records were subpoenaed. Your other issue in your motion for continuance is that there are fears of immigration enforcement as it relates to your witness. Don't know what to do about that. There's going to be fears. So I can't grant a motion for continuance based upon a person's fears of coming into court. Now, if somebody wants to agree to have the witnesses by Zoom, you can, but otherwise I'm not giving a motion for continuance because someone is afraid of immigration consequences. Because if that's the case, then we will not be able to have a trial who knows when. All right, anything else?
Not from the state?
All right, motion for continuance is denied. And state any 404B information that has to do with this defendant's relationship to the client. That's not going to be admitted unless the defense wants it admitted.
We understood, Judge.
All right.
Is there a time you like this defendant?
Yes, I'm going to have the jury's going to be out in the hallway by 11:30. I anticipate us recessing and doing jury selection at 1:30. All right, thank you. David Escobedo. Oh, I'm sorry, counsel. I'm sorry, Mr. Escobedo. Just have a seat. I'm waiting for your attorney to give the court information. This is 1:30. All right, are the parties still here on Pearl Gonzalez?
Yes, ma'am.
All right, so the email,
Now think about Angel Cepas Ronda's case. It wasn't about guilt or innocence today. It was about timing. The defense tried every angle to stall, but the judge shut it down. This shows how courts value efficiency and responsibility just as much as fairness. The clock can't stop every time the defense asks. The judge's denial sets the tone. Trials must move forward, and both sides must adapt. For Angel, it means the pressure is higher than ever, with less time to prepare.
court received from pretrial services that she is not in compliance. And what they sent me, they said, as of this writing, no, ma'am, she has failed to comply with pretrial. The defendant has not responded with us since 7/17, and multiple attempts have been made by her officer.
Thank you for the update, Judge.
Sure, no problem.
I know she's indigent. I believe it's a possibility of her being perhaps living on the streets. She was in custody more than 90 days without an indictment being generated, so that's what the PR bond did issue. I guess if we could be heard on, I guess,
Sure.
state may want to be heard on.
All right, the court is calling 2025 CR 008155, State versus Pearl Gonzalez. Can I have parties announce?
Jason Garahan for the state, Your Honor. Renee Munoz on behalf of Ms. Gonzalez.
All right, this hearing was scheduled at 9 a.m. It is now 10:46 a.m. The court received a violation report that the defendant is out of compliance with pretrial services. According to the violation report, they state that she attended orientation and left, refusing to provide a UA sample to our office. For the record, both parties had no objections to the court emailing pretrial services to see if Ms. Gonzalez was back in compliance. And the email the court received is that the defendant is still out of compliance and has not been seen since July 17th, and they made multiple attempts to contact her. Defense, is there anything you wish to put on the record?
Yes, Judge. I know that she is indigent. She's being represented by the Public Defender's Office. And we believe there's a chance she may be homeless, otherwise.
And Pearl Gonzalez? Her case is a blunt reminder. If you ignore the court will catch up with you. She wasn't just neglectful. She was defiant, skipping tests, failing to report, not even showing up to court. It's a recipe for disaster. The judge's swift ruling wasn't surprising. It was inevitable. Her story is a clear warning to anyone who thinks they can cheat the system. The law always has the final say, and in Pearl's case, that meant immediate consequences.
Able to abide by the current conditions as set. We respectfully request that a summons issue in lieu of a warrant.
All right, State.
State requests judge's warrant, Your Honor.
All right, the court will issue a judge's warrant. Counsel, if your client makes an appearance, the court will reconsider. But for now, the court is issuing the judge's warrant and remanding your client without bond.
I understand. Thank you, Your Honor.
All right, thank you. Reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. State?
Your Honor, the reason that this agreement was struck or offered by the state and accepted by the defense was because the offense date and for the offense that we're here for is February 13th of 2023. The defendant did have some additional felony charges for which she was indicted for in 2024. However, this case had not been turned into our office yet. And so regarding the 2024 indictment, she did take accountability and enter a plea on those cases. However, this case was still outstanding at the time. In that case, she had 255 days worth of credit in the Bexar County Jail that had this case been filed at the time, she would have received credit for. And so I took that into account, and that's why we reached the agreement that we did.
All right.
That's correct, Judge.
All right. The court will follow your agreement, find you guilty, sentence you to $800 time and money to run concurrent, 2 days in the Bexar County Jail on 1244. There should be no contact with Freda Flores. The court will give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal.
All right, guys, here's the bigger picture. These three cases, all different, share a common theme: accountability. Elizabeth was given probation, but with razor-thin margins for error. Angel was forced to face trial without extra time. Pearl had her freedom yanked away for ignoring the ADET rules. Each case shows how the courtroom balances fairness with authority. Sometimes mercy is shown, sometimes it's denied, and sometimes it's stripped away completely. But the message is always the same. In court, actions have consequences.
You do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. I understand people get upset with the way people are driving, and it appears from reading the police report, both of you were in the wrong. She was in the wrong for riding your bumper, almost hitting you. She was in the wrong for throwing some sort of liquid at your vehicle. You were in the wrong and in a dangerous situation from getting out of your vehicle and striking her vehicle. You understand?
Yes, sir.
All of this could have been gone left, farther left so quickly, because if she would have had a gun, she would have ended up shooting you. And then everybody would say, well, was it justified? Was it not justified? Because she came at her vehicle with a weapon. You understand?
Yes, sir.
So what I've discovered is when you're driving, just have patience. Don't honk at anybody unless it's to say hello. And you know what my mom always told me? Let them pass. She's like, just let them pass. Your job is to get from point A to point B safely. You understand?
Yes.
All right. Good luck to you. Have a great day. Court is calling 2025 CR 005379 State versus Adriana Ramos. Could I have parties announced, please?
That's all, Ms. Miles.
Adriana Ramos.
All right. So it is the court's understanding that your attorney has filed a motion to withdraw. Are you aware of his motion to withdraw?
Yes.
All right. So I don't do ex parte. However, managed assigned counsel just sent an email to the court coordinator and
Watching these hearings, you really see the weight a judge carries. Every decision affects not just the defendants, but the system itself. One wrong call, and public trust erodes. Too much mercy, and the court looks weak. Too much punishment, and it looks unfair. Judges have to walk that tightrope every single day. And in these cases, you saw the balance. Mercy for Elizabeth, discipline for Angel, and tough enforcement for Pearl. That's how courtroom authority is maintained, by adapting to each case while holding the line.
court is in receipt of that. Any objections to the court reviewing what managed assigned counsel has sent?
No, Your Honor.
All right. All right. So the email that has been sent to me, and I want to explain to you, Ms. Ramos, normally I do not allow motions to withdraw just because there's some sort of lack of communication, but based upon what managed assigned counsel has sent, I will grant the motion to withdraw. All right, you may be excused.
Be available for the next council with any questions, John.
All right, if you will just remain in court.
Y'all will.
Thank you. So then the next question becomes, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Amen.
All right, you can lower your hand if you'll state your name for the record.
Adriana Ramos.
All right, so Ms. Ramos, the questions I'm going to ask you, it has absolutely nothing to do with the facts of your case. Please do not tell me anything about the facts of your case because your attorney would not want you to, okay?
Yes, ma'am.
All right, so are you able to afford a new attorney?
No, ma'am.
All right, do you have any funds in a bank account, any savings?
Not really. My mom just passed away in May, so I just had to bury her.
Okay.
I do have a job at AutoZone, but it's part-time.
Okay. So do you have any money in a savings?
No, ma'am.
All right. So I'm going to have a new attorney appointed to you, and that new attorney is going to be Orlando Castillo. All right. So if you'll confer with him.
Yes.
All right. She's set today. We're off the record. She set today for it's just discovery today.
Okay.
So
Here's something to think about. What do people watching these hearings walk away with? For some, Elizabeth's chance at probation shows hope. For others, Angel's denied delay proves the system won't tolerate stalling. And Pearl's arrest warrant shows that skipping out never ends well. These cases aren't just legal moments, they're public lessons. They remind everyone watching that the justice system doesn't forget, doesn't wait, and doesn't play games. Every case is an example, every ruling a reminder of how serious the stakes are.
that's what we're here for.
Okay.
So he'll confer with you, and then he'll confer with the state, and then he can approach me when you're ready.
Yes, Judge.
All right, you're welcome.
See you outside.
Hello.
Morning, Your Honor.
Good morning. All right. All right. Mr. Lopez, today is your plea deadline date?
Yes, Your Honor. I'm covering for Ms. Knowles this morning. When I covered Mr. Garrihan, there's still some discovery outstanding, and they're asking the court to reset the plea deadline one time to allow the state to provide us that discovery.
Okay, what discovery is missing?
Judge, it is actually missing. I looked on Veripic and they don't have the body cams on there, and that's what's missing.
Okay.
And I was unaware. The offer had been extended. I just was unaware until presently that I believe Caitlin Knowles was the main attorney on this. And I was just notified today that she had notified Mr. Solansky that.
All right, so when do you believe you'll have that?
2 weeks to 4 weeks, Judge. I mean, Megan Galloway has just emailed BCSO to obtain that.
All right, Ms. Ferguson, if you'll extend this plea deadline date for 30 days, there'll be no further extensions.
Thank you, Your Honor.
Thank you. What date? All right. August 21st. Thank you for addressing appropriately for court. Once you sign the reset form, you're excused, okay? Thank you. Thank you.
Excuse.
Yes.
All right, who's here on Adriana Ramos?
Hello. All right, have you had a chance to meet with your attorney? All right, and defense?
Yes, Judge. I've met with my client, just assigned today. I need time to go through discovery. And so I asked that we receive a new court date.
All right, Ms. Ferguson, on this, do 30 days for discovery and
All right, guys, let's break it down plain and simple. Elizabeth's story is about redemption. Angel's story is about discipline. And Pearl's story is about consequences. 3 very different defendants, 1 courtroom, and 1 judge who laid it out with authority. No 2 cases are ever the same, but the lesson always hits home. Whether you're asking for mercy, pushing for more time, or running from responsibility, the court decides your fate, and once that gavel drops, it's over. There's no escaping it.
counsel, there's going to be a quick turnaround after the discovery. All right, August 21st, counsel?
That works, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
You're welcome.
David Moses Escobedo.
David Moses Escobedo? Thank you. All right, the bond was reinstated. Why is he still in custody?
It is not showing that it's been reinstated, Judge. I looked online yesterday, I spoke with the bondsman. They said that they had agreed to it. I didn't see them file anything.
Yeah, I've signed everything. It is 2025 CR 02743.
Odyssey didn't show any updates in regards to that.
Okay, because he should have been released.
Mm-hmm. 2743.
No, the bondsman sent something over. All right, you want to get in touch with the bondsman?
Okay.
All right.
They need to file something.
But they did file something. I remember asking that the bond be restored.
Okay.
So if you can have them, Mr. Escobedo, just have a seat. If you can see if they can find it. Yeah. Michelle Battles. If you'll come forward, please. Hello.
Hi.
Hi. So you were late for court. Here's the thing. You cannot be late for court. You've been here before. You know where the court is located. Other judges, guess what they would have done? Taking you into custody. Once you're late, you're late. You understand?
Yes, ma'am.
Court starts at 9 a.m. All right, state. Has an offer been tendered?
Judge, an offer was tendered on the cases that are indicted currently. She, as the court can see, she's got a number of pre-filed cases.
So what did we learn from today's hearings? The courtroom isn't just about punishment, it's about choices. Elizabeth was given one last chance to prove she can change. Angel was told to face his trial head-on, ready or not. Pearl was shown that